Thank you, David. And thirdly, another David Pitlarge of Hill Dickinson. He is going to talk about piracy and charters. Again, a burning issue. Well, not quite burning, but fairly explosive.
Thank you very much indeed, Bruce. Buonasera, everybody. I'm the last speaker. I'm not quite sure whether I have any particular duty to wind things down or liven things up. When Francesco first asked me to speak, he asked me to talk about something that was hot. Now, I'm, as some of you know, a lawyer who practices largely in the area of shipping contracts. And lawyers in shipping contracts don't often get asked to talk about things which are hot. Looking at the agenda, and I made one or two suggestions to Francesco, and I could tell from his groans that my suggestions were not considered suitably hot. However, looking at the programme, we could see that there was a gap in the consideration of piracy, which, as Bruce said, is a burning, not literally as far as I can tell, issue. And obviously we wanted to speak about that. The heading in the brochure says Piracy and Charters. I've changed the title slightly, and it's called Reflection Following the Latest Cases. There are two recent decided English cases that have come to the High Court this year. And I just wanted to go through them because I think they illustrate quite neatly some important principles of wider application. I think it's a timely review as well. The lawyers, our firm, David's firm, many others, were asked to consider piracy probably about 2 years ago. I'm sure many of you will have gone to large presentations and so on and so forth. Some of the issues then, I think, have fallen away. The interesting question about how many pirates do you need for piracy, or when does it become a riot? Because, of course, that is material to the insurance cover. We also see changing trends in the pirates' activities, and most importantly of all, increasing sophistication in the avoidance techniques for such attacks. And I think that's perhaps the most critical factor, because I think the consensual approach to dealing with that is going to shape the owners' and carriers' obligations as we go forward. The first case, it was an insurance case. It's called Masefield and Amlin. Part of my general theme today is going to be that there are no special rules for piracy. It's dramatic and traumatic, but the simple rules of contractual construction and what one might call a legalistic approach are not displaced by the high drama of piracy. This case involved, funnily enough, a cargo policy, an open cover policy for a consignment carried on the Bunga Mela Dua, owned or at least operated by MISC, the well-known Malaysian operators. She was detained for 6 weeks by Somali pirates. There were active negotiations throughout, and this was important. And it seemed that there were always good prospects of early resolution. MISC engaged with the problem, and in due course, the vessel was released after 6 weeks. Piracy was covered by the policy. In this respect, it didn't really differ from a hull policy. And of course, the Marine Insurance Act, which has such a bearing on the way in which the risks are allocated in marine insurance, covered the policy as well. Masefield, the cargo owners, argued that there was a total loss on seizure. They wanted to recover their net loss. They referred to an old case of Dean and Hornby in 1854. I have to say as an aside, I was amused when Giuseppe De Santo earlier considered a case of 1956 to be an old case, actually. If you look at some of the things we cover in English marine insurance, that's not the case. Anyway, Masefield's case was, upon seizure, looking at the old case, when the pirates obtained dominion over that cargo, then there was a total loss. Why? Because the Marine Insurance Act tells us that once the property has been irretrievably, once the assured is irretrievably deprived of his property, then an actual total loss should ensue. So Masefield's argument was you disregard the later recovery and also the prospects. Their second point was that there was a CTL. In this case, they had reasonably abandoned the cargo and an actual total loss was inevitable. Unsurprisingly, in my view, both arguments failed. It was always clear that the cargo was going to be recovered, or certainly not irretrievably deprived. Interestingly, in the judgment, and you might see this raising its head in other contexts, there was a good judicial consideration of Somali piracy and the importance of and the prospects of obtaining or paying ransom and recovering the property. As to the CTL argument, that fell away because there was no abandonment. Abandonment in this context does not mean a notice of abandonment. The interesting point of wider application is the third argument that the assured ran, and that was you should disregard the ransom payments and all of the prospects of recovery that flow from that, because ransom is contrary to public policy. Now that's public policy, not illegality. Illegality, now we go back even further, was repealed, the statute against paying ransom was repealed in 1782. There was, so the law report says, no issue as to legality under Swiss or Somali law, whatever that might be, or Malaysian law, the law of the flag of the vessel. So there was no illegality. However, as I say, the assured's answer was this was still contrary to public policy. If you pay ransoms, you encourage pirates, and that's something which we should discourage. The court rejected that argument as well. Indeed, I think if you read the judgment, you'll find that it was erring the other way. If it was to uphold that argument, then kidnap and ransom insurance would be unenforceable. Similarly, the established principle that ransom payments are a sue and labour expense would also fall away. Just a note there, that's English law. The position might differ under other laws, and you could see a situation, and we have seen it at Hill Dickinson, where under other insurance contracts, the payment of ransom is unlawful. So I take from that a general principle that no matter how unfair or onerous and burdensome the piracy, seizure by pirates might be, there's no overarching concept that displaces what the parties have agreed in their contract. And that seems to me right, and it's consistent with what Peter and Simon Curtis were saying earlier. Indeed, our next case concerns off-hire in the Saldanha. Many of you know this. I'll run through it quickly as I run out of time. Again, the judge recognized there's no relevant concept of fairness other than the contractual balance. In that case, it concerned an off-hire clause. The vessel was detained again for about 2 months. The charterers said that was off-hire. They scratched around and read through our well-known clause 15 and said there was an average accident to the ship or cargo. That was dismissed. Similarly, default or deficiency of men, and, as was bound to be the case, any other cause. So the court takes a hard and fast rule and parties to their bargain. And I would say there that a similar rigor will apply to some of the other hard rules. For example, the rule that if a charterer redelivers late, he will have to pay his damages, subject to any adjustment in the contract. The judge also recognized that if you want to shift that burden or change the allocation of risk, you can do so. And the classic way is to put whatsoever in your charter. As we move on, we have the BIMCO piracy clause, which, as many of you will know, has a 90-day cap on the payment of hire. The charter is bound to pay the hire, but only for 90 days. So with all of this, I have to say, for many people, the surprise about the Saldanha was not the result, but was the fact that it went through arbitration and on to the courts in any event. Is this the end of the story? I'm not so sure. Of course, hire, which we're looking at here, is only the suspension of the primary obligation to pay. It's independent of breach. If the charterer could find that the owner is in breach of the charter party, then he might still recover those damages. A 90-day cap is not much help to a charterer. It's still a lot of money. I don't know what 90 days for a caper in the first half of 2008 would be, but it's certainly something worth constructing a damages argument about. As we look forward, we're guided now by these principles that there is nothing special in piracy. You will look to the contracts. So you have to be as careful as you ever were. And I think in particular, when you're looking at adjusting your clauses by adding extra words, you have to make sure that you understand what they mean. And certainly our experience has been that some of the ways in which this has been done, adding the words convoy if necessary, or no aid, and doesn't always help. The final point, and I think is perhaps the most important point, and it goes back to what I said at the start. This question about whether the owner is in breach will be judged ultimately by the approach of the market, by the approach of reasonable operators. And I just draw your attention finally to Best Management Practice 3, which as you can see is quite substantial, but nowhere near as substantial as the European regulation Mark Clough showed us this morning. The fact is, if you depart from what is accepted as a reasonable norm, an owner might expose himself to those claims, and that could express itself in the charter party context, as we've just seen, for general average contributions under a bill of lading contract, and even other issues which come up in the contractual context of seizure, things like cancellation clauses of charters and MOAs. So there it is. It's a very brief run through a big subject. Thank you very much indeed.